Welcome to the I Got Fired podcast, where we help people who've been fired or afraid that they might be. My name is Tom Spiegel, and I am founder of the Spiegel Law Firm. And today we are going to continue our series where we talk about the stages in a court case. But before we do that, a little bit of legalese here. This podcast is intended for educational purposes for you. It is not intended to be specific legal advice for your matter. If you want specific legal advice, then you got it. You need to go hire yourself a lawyer. So last time we talked about service of process, and the time before that we talked about what it is to kick off a lawsuit is filing a complaint. And today we are going to be talking about the answer to the complaint. And the reason that all of this is important to you is that this is really sort of the secret language that lawyers use to talk to each other and to the judge. And if you're not a lawyer, if you're not a litigator, some of these terms, using the word answer, everybody knows what an answer is, but it means a specific thing in court. Similarly, a complaint, everybody knows what a complaint is, but it means a specific thing in court. And the more that you can know about these terms, the better you'll be able to participate. If you're handling your own case, you're going to need to know these. But even when you are working with a lawyer, you're going to be better able to participate and understand what they are saying to you, because sometimes lawyers and judges do forget that you don't know what we're talking about. And so lawyers sometimes will use these terms, when they're talking to you, and unless you've been through law school, you won't know what the lawyer really means. And so this really gives you an insight into how the court system works and the language that lawyers use to talk to each other and to judges. So the more that you know about that, the more that you can effectively participate in your own case. Let me also say that all of these things that I am talking about in this series can also be found in the Federal Rules of Civil Procedure. You can find them on Google. They're free. Just type in Federal Rules of Civil Procedure, and you will pull these up. And they are surprisingly free of legalese. They're pretty written in pretty plain English, and when you look at them, you'll be able to understand what they mean. Now, sometimes in the application of these rules, it can get a little complicated, but in terms of like laying out the steps, it really is almost like a recipe. Like if you're going to bake a cake, right? You just follow the recipe, A to Z. The same thing with the Federal Rules of Civil Procedure. It really will help you, walk through the process of a piece of civil litigation. If you take the time to read them, then you'll be the step ahead of many lawyers who haven't looked at it in a number of years. So let's get to the next step in the process after service, and that is the answer. And you can find this in Federal Rule of Civil Procedure 8. It's also the same one that talks about the complaint. And an answer, as it sounds, it is a response to the complaint. Now, the answer it's not a defense of the lawsuit. So the answer can just, for example, if you make a statement in the complaint, I was discriminated at, my job. It's something simple like that. Of course, you're probably not going to say exactly like that, but let's say that's what it is. Then in the answer, all the defendant has to do is say denied. And a lot of times you'll see that in an answer. The complaint may be voluminous and have a lot in it, and you'll look at an answer, and a lot of it, the response will be denied, 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 denied. Sometimes as a matter of strategy, the defendant will decide to put more information in the answer, just for the same reason that you might put it in a complaint. This is going to be a public document. If a case is not uncommon, settles well before we get to, let's say, some of the other stages we're going to talk about, summary judgment or certainly trial. If anybody's looking at the case file, this is what they're going to see. And so the defendant may want to get its side of the story out. And so it may include a more substantial answer. But the requirement of the rules is just that you deny claims that you believe to be untrue. If there are things that you admit, then you admit them, or there can be a hybrid answer, right? You might say, let's say in your complaint, you say, I worked at company XYZ for 10 years and was fired for discriminatory reasons. The answer might say, it is admitted that plaintiff worked at the defendant company for 10 years. The remainder of this allegation is denied. And there may be some things in the complaint that often there are that, the other side's not opposed to admitting. For instance, some of these sort of, set up, kind of laying the groundwork of what happened. Like, for example, I worked at this company. Well, they're going to admit that. I worked at this job description. They're going to admit that. And it can be a good way when you're doing your complaint to understand that once the defendant admits that, then it is a fact of the case. And again, the defendant, if they're of any kind of sophistication, isn't going to admit something damaging to it. But it can be helpful. Then you don't have to establish that later in the case because everybody agreed. Hey, I worked at this job. I worked there for this time and I was paid this much, or whatever it is that you put in the complaint. So the answer is just that. It is just a response to the complaint. And again, it sort of depends really sometimes on whether if the company is covered by an insurance carrier, they're not going to spend a lot of time on this answer. It's just going to be admit, deny. They're going to be very short statements. But I do recall one time this is early in my career when I worked in a case and we represented school boards. And this was I was actually on the defense side at that time, but this was a case where the school was being sued by a former principal. And it was a nasty dispute. It had been in the papers. It had been very public. And in that instance, the school board, which is the entity that was being sued, decided that they wanted to include a very fulsome response to the complaint. And so we had a pretty involved answer with a lot of narrative, but that tends to be atypical. So what you can expect is a short statement of most of your claims, denying many of them. That's not uncommon. One thing in an answer that is crucially important are counterclaims. Two things really. One are you'll see the defendant a lot of times will plead. It's called pleading, which you put in the complaint. Will plead what's called an affirmative defense. And under the rules, if you look at Rule 8, you'll see that there's a list of things that the defendant has to plead there at the answer stage, or they may lose the right to raise it later. For example, statute of limitations would be one. There's a whole laundry list. And sometimes you'll see defendants, they'll throw them all in there or throw a bunch in there. They may be of import to your case. They may not. Sometimes it's just filler, or the defendant kind of doing a little CYA to make sure they don't leave anything out. But of greater potential consequence to you, one thing that can be filed with the answer is what's called a counterclaim. And that is, as it sounds, they are essentially throwing a stone back at you. It's essentially a in some ways sort of a reverse lawsuit. Like, oh yeah, you say that we violated this law. We're going to put on evidence that you violated this law. Now it has to be related to the subject matter. So if I'm suing you for my time at work, well, they can't sue me for some some property issue or something that doesn't have anything to do with the case. It has to be related to your employment there. And what you will sometimes see in these cases, that the counterclaim can be very serious and can in some ways derail your case. And defendants do that purposefully. And I'm not saying that anytime a defendant files a counterclaim that you're in some kind of trouble, but these can be significant elements of the case. So what does that look like? If I'm fired and I've been fired. I've left the company. I've gotten another job. I have filed a complaint saying that I was fired for race discrimination reasons, and the defendant can then turn around and say, well, we think we not only did we not fire you on the basis of race discrimination, but we think you violated something called the duty of loyalty to our company, because while you were there, you were soliciting people, you were trying to get people to leave with you to start another business. That can also be a violation of a non-compete, which could be another basis of a counterclaim. We see it too with, when employees take a lot of information from the company. Sometimes people get fired and their instinct is to take a thumb drive or some other kind of storage device and download a bunch of stuff on their way out the door. Often for good intentions, they think they have a case and they want to make sure they take all the evidence with them. But in doing that, they take a bunch of other stuff that belongs to the company, perhaps trade secrets, confidential information. There are all kinds of laws that protect computer databases. Sometimes we've seen employers try to use those laws to say the employee violated, these laws by accessing the computer database, and they can be very expensive to defend. And so this can be, as a matter of strategy, if you're on a contingency fee basis with your lawyer, that meaning you're not going to pay anything, at least attorney's fees, unless and until there's a settlement or a win at trial. All of a sudden, this can become very expensive for your side. And what you'll see many of firms do, including ours, is with the retainer, we'll say, hey, we are representing you on contingency, to bring this underlying claim. But if you get a counterclaim that requires us to defend it, you're going to have to pay on an hourly basis. So just something when you're talking with your attorney at the initial stages, just to be first honest with him or her about everything that you did. I mean, everything that you tell your attorney is protected by attorney-client privilege, but you want to make sure you tell them, not only the good, but the bad and the ugly, so he or she can be prepared for it and can advise you that, hey, we can file this lawsuit, but they're going to have this ability to file this counterclaim, which is going to affect, A, the way you pay for the case, and B, how long this case is going to take. Again, I'm not suggesting that you need to roll over anytime a defendant either threatens or actually files a counterclaim. It tends, I would say rare, but I would say most cases that we file, we don't get counterclaims. But it does happen. It's certainly not out of the realm of possibility and something you need to be prepared for. I recall a case, this was back when I was clerking for a judge, that the DC government had filed a breach of contract action against this very large developer, because the developer had purchased this is sort of interesting, the air rights, over 395. So the developer purchased the rights to develop that, to put a kind of a bridge over it and build condos or whatever it was. And as part of that, so they had this option to use those air rights for a certain number of years. And the deal they worked out, with the city was that, for the first number of years, the payments would be very low. And then only towards the end would there be sort of this balloon payment that the developer would have to pay, because the idea was, right, like the developer doesn't have to pay much while it's developing the property. Once the property is up and running, it will have all this income, and then it will be able to pay the city for the rights for this development. But it didn't happen because this developer argued that the city council essentially decided that it didn't want to work with this developer anymore, and that it was a political situation. And they put all kinds of requirements on what he was going to be able to build and the way he was going to be able to do it, that essentially made it impossible for him to do it. So he never used the air rights. So what happened? It got towards those later years where this balloon payment was due, and the city came knocking on his door and said, hey, it's time for you to pay up. And he says, his argument was, I don't have to pay you. It's you guys are the ones who, you were the one who caused this not to go through. So I'm not going to pay you. And the city sued him. and he hired a very good lawyer. And so then he, through his lawyer, counterclaimed against the city, and he said, not only do I not owe you any money, District of Columbia, but you in fact owe me because you breached the contract. You were the ones who played these political games and made this impossible. And he ended up winning that. So the jury came back and found that he didn't breach the contract, but that the city did, and that it owed him millions of dollars. So sometimes the counterclaim can become the tail that wags the dog and can become the more important factor. So all that to say, that can be an important part of an answer. Usually you're not going to be surprised by it because there's going to be some back and forth with your employer beforehand, and they're going to let you know that they're thinking about, that they plan to file a counterclaim because they in part want to scare you away. But it's something you want to talk to your attorney about. So in review, we've started the lawsuit process by filing the complaint. You've actually gotten it served as you were required to do and follow the steps under the rules of civil procedure and state law. After the service, the court is, as part of the service, there's a letter from the court to the defendant saying you have 21 days, or however many days it is. And the federal system is 21. You have 21 days to respond to this complaint. And then the defendant will file its answer, and it will look just like I said. It's going to be admit, deny, admitted in part, denied in part. And in some instances, there may be more narrative in the answer if the defendant is trying to get its side out early. And could be some affirmative defenses, which usually are not that serious. They're often boilerplate. The bigger piece can be a counterclaim, which is not a guarantee. The defendant doesn't have to bring them there. Often they won't, but it's something to talk with your attorney about, early in the process, because they can be a real game changer. So we have made it all the way through the answer. We are at Federal Rule of Civil Procedure 8, and I should say that the counterclaims are under Rule 13. And the next time we're going to be talking about extensions, extensions to file, which happen throughout the process, and how you should think about them. If you found this interesting or helpful, please give us a positive review. It helps people find us. You can also go to our site, thecareerrocket.io, and there you can get on our free email list where we will give you the latest and greatest in employment law and other tips and tricks from other professionals on how to keep your career on an upward trajectory. Hope that helped, and I wish you guys the best of luck out there.